Hey YouTube, Natalie here. Hope everyone is doing well. So I wanted to come to you guys on this rainy Sunday when I normally would be doing my skincare. I'm preparing a few videos. I want you guys to make sure that you have your channel notification on, that you are subscribed, you like the video, comment on it, everything, so I can see you guys, interact with you, but also so that you know when I'm about to upload a video. And I'm going to be doing some really interesting stuff in the next coming weeks or so. But I got an excellent question on my last Q&A video about the Megan Thee Stallion v. Tory Lanez situation. And I thought I would answer that question while I'm doing my skincare. So I'm going to be doing my skincare. I know that sometimes you guys get put off by me multitasking, doing more than one thing at once. And some of my viewers are men. You might not want to see me doing that, but everyone has skin and we should all take care of our skin. And another thing that I get asked a lot is, how do you keep your skin so nice? How does your skin, look like that? I don't have perfect skin. Obviously, I'm not wearing any makeup right now other than some leftover eyeshadow, but I don't have perfect skin. I have skin issues, but I take care of my skin. And I think for 36, my skin looks pretty good, So I wanted to do a little bit of skincare with you guys, and I wanted to talk about this question that my viewer had. So let's jump right into it, 1 minute and 34 seconds later. So first and foremost, the question was like this, and I'll maybe put it up on the card over here. But the question was like this. The young lady asked me, I think it was a lady, asked me, how can Megan see the intent of the person that shot her? Say Tory did shoot her. How could Megan be able to see his intent when her back was turned? And I thought it was an interesting and good question because Tory basically said the same thing in his Instagram live. So Tory said, how is it that you can tell that I intended to do anything or I did something maliciously or viciously if your back was turned? So the first thing to realize is that intent is an element that needs to be proven of any crime. The level of intent or the type of intent that needs to be proven depends on what type of crime it is. But the intent that needs to be proven by the prosecutor to the jury. It is not something that the complaining witness or any type of witness needs to be able to testify to. So the witness doesn't testify to the intent of the defendant. The prosecutor has to prove the intent of the defendant in order for them to prove the crime. It's an element of the offense. So for example, the state has to prove that someone is operating or someone is possessing an unregistered firearm. Then it's the state's burden to produce like a records check of registrations throughout the county or the state that they're in to show that this person is not registered in said county or state. So that's basically saying that the police officer doesn't have to prove that this person is an unregistered gun owner. The prosecutor has to prove that to the jury. Does that make sense? So that's not something that Megan would testify to. Basically, intent is read several ways. Well, first of all, let me just break down what intent is. Intent is, like I said, one of the elements of the crime. And if you go back to British common law, most crimes require two elements, right? There's a separate version of crime that doesn't fall into this category, but most crime falls into this category. At the baseline, they require two elements. Actus reus, which is the bad act that the person does in order to commit the crime, or mens rea, right? Mens rea is the bad mental state that the person needed in order to commit the crime. So the different types of intent, right, means that is the mental state that the person had to have in order for them to be convicted of the crime. And then I'll break down the different types of mental states that there are for intent. So there is malicious intent, or in the state of Maryland, they also can call it malice aforethought when it comes to like a homicide crime. But malicious intent is where, you set about to do something, you had an opportunity to desist from doing that thing and you did it anyway. Knowingly is another form of intent. So it's a lower than malicious, right? You knew what the reasonable and foreseeable outcome of your actions would be, and you still undertook to do that action, even if you didn't have a malicious intent towards either the person or the thing that you were committing the crime against. There's recklessly, and reckless just means that you do something with a willful disregard for the natural and foreseeable outcome. There's willfully, right? And then there is negligently, right? So negligently just means that, it could have been something that you did accidentally, but you had a duty of care not to do the thing that led to the commission of the crime. And because you didn't exercise your duty of care and you breached your duty of care, the crime came about or the bad thing happened. And so you're guilty of the crime, even though you didn't mean for that thing to happen. I think a good example of that is negligent homicide, where you undertake to, let's say you're playing around with a gun and the gun accidentally goes off, and then, your kid is in the room with you and your kid is killed, right? That could be a negligent homicide because you shouldn't be playing around with a gun with your kid in the room with you, right? Because the natural and foreseeable outcome of your actions is that the kid could be killed. So those are the different levels, and every state defines them or categorizes them differently. Some will say malice aforethought, some will say willfully, knowingly, maliciously, but those are all elements of intent. And it is the state's burden to prove Tory's intent, or anyone that's a criminal defendant, it's the state's burden to prove their intent, right? So Tory doesn't have to prove that he did not have the intent to shoot Megan Thee Stallion, but the state does have to prove that he had the intent. So how does a state's attorney or prosecutor, district attorney, so the question becomes, how does the prosecutor prove the intent of the defendant, right? And it's a good question because many times, so it's a good question of how the prosecutor, not Megan, but how the prosecutor will be able to prove Tory Lanez's intent. Because intent can be read one of two ways: through the person's actions or through the person's words. So, if it was malice aforethought, right, which is basically premeditation, right? If that's your intent that the state has to prove, if the defendant sent a bunch of text messages to a hitman saying, I need you to take out my wife, then through those words, you can determine that this person intended for their wife to be killed, right? They meant for that to happen. It was not an accident. The prosecutor normally does not have that. They normally don't have it where the defendant has said through affirmative words that they intended to commit the crime. But in this particular case, the allegation is that Tory Lanez said dance B word to Megan Thee Stallion before he shot her, and he denies that, okay? So if she testifies that he said that, then those words would be evidence of intent. But that's just an example. Let's forget that we're even talking about Tory Lanez. I'm just trying to teach you guys the answer to this question. That's just an example, okay? So if he says dance bitch, that would be an example of someone acting with the intent to shoot someone, meaning that I intended to do it. It was malicious or willful or whatever the case may be that's required for the particular crime, because I said I was going to do something right before I did it, right? Okay. So, but let's say, for example, Tory didn't say that, okay? Because that's contested by him and by his people. Let's say that he didn't say dance B word. If Tory or whomever shot the gun more than once, that can be read as an intent to cause the assault to occur, okay? So that's an intent to cause the assault to occur, because it might be accidental the first time the trigger is pulled, but it's not accidental the second time. And even if it is accidental, playing with a gun, tussling over a gun, arguing over a gun, anything like that can be read as reckless behavior or negligent behavior. But it goes outside the realm of recklessness or negligence if you do the activity more than once. And there have been many cases in multiple states and at the federal level that have found this. Another example would be, say, for example, stabbing. So if you are in a dispute with someone and they are attacking you and they stab you once, that could be accidental, maybe even self-defense. But if you stab the person multiple times, if they stab you multiple times, then that can be read as an intentional behavior. See what I'm saying? And then the jury is given a jury instruction, and we'll get to jury instructions in a little bit. Hey, editing Natalie here. So of course, I did not get back to the jury instruction. So what a jury instruction is, it is at the conclusion of the case, the judge will instruct the jury on how they can consider what the law is, basically. And they tell them basically how to apply the facts to the law. So every state's jury instructions are different, but in the state of California, what the jury will be instructed if this case were to go to trial, and again, we don't know if it will be, but if for any case, because I really think this is a general question that has a lot of value outside of Tory and Meghan. But basically, the people, which is the state, the prosecutor, must prove not only that the defendant did the acts charged, which would be the shooting, but also that he or she acted with a particular intent and or mental state. And it's a malicious intent for the purpose of Tory's case. The instruction for the crime and the allegation explains the intent or mental state required, and an intent and or mental state may be proved by circumstantial evidence. And one of the types of circumstantial evidence is the actions of the person. So the direct evidence of the intent would be what the person says: I intended to shoot you, or dance, B word. The circumstantial evidence of the intent would be the surrounding actions, where the jury can make an inference as to what the intent is. And if there's multiple stabbings, multiple shootings, multiple hittings, it can be inferred that the requisite intent is met. So that is what a jury instruction is. And jury instruction is what the judge tells the jury the law is before they go back to deliberate. And they are allowed to consider circumstantial evidence when considering whether or not the person had the right intent. And so even if the complaining witness or victim cannot testify as to what the intent of another person is, the jury can draw those conclusions. And I hope that makes sense. But if we bring it back to the realm outside the general and back to the specific of Meghan and Tory, Tory is charged with assault with a firearm or assault with a semi-automatic weapon. And in order for the state to prove assault, they have to prove that under the Penal Code of California, 240, states that an assault is an unlawful attempt coupled with a present ability to commit a violent injury on the other person, okay? So we know that there's injury, whether that injury was caused by shrapnel or a bullet, that's a gunshot wound, right? We know that there's injury. We know that that was caused on another person, Megan Thee Stallion. We know that the person had the ability to cause that injury because whoever shot the gun had the gun in their hands in order to shoot it. And then the question is there an unlawful attempt? And the unlawful attempt is the pulling of the trigger. And if you pull that trigger more than once, the state is going to be able to read into the circumstance that the activity was undertaken intentionally, okay? These are the elements of criminal assault in California. That one, the defendant did something that was likely to result in the use of force against someone else, and that would be pulling the trigger. The defendant did so willfully. So willfully is the intent element for assault in the state of California. So under the California law, an act is done willfully if it is done on purpose. This does not necessarily mean that the defendant intended to break the law or cause any harm. It simply means that the defendant purposely did an act that could have resulted in harm. So the person could have thought that they were playing. The person could have thought that this would just be between friends. The person could have thought all types of things. But if they did the act, which is the pulling of the trigger on purpose, willfully, then they would be guilty of the crime. Okay? So that's what the California definition of willfully is. The defendant was aware of the facts that would lead a reasonable person to believe that this act would directly and probably result in force being applied to the other person. So let's break that down. If the defendant was aware of the fact that would lead a reasonable person, so a reasonable person would believe that by pulling a trigger, another person could potentially be injured, right? And that would directly and probably result in force, either through shrapnel, bullet, fragments, glass, anything like that, could potentially lead to that person being injured, right? Or force being applied to that person, because it's not even requiring injury, it's just requiring force. And that when the defendant acted, she or he had the ability to apply force to the person, meaning that they weren't disabled, they weren't away from the gun, they were in possession of the gun, they had the ability to do the injury or the harm, and they applied force to that person, okay? So that is what assault is described as in the state of California, and then he has the added element that it was assault with a semi-automatic weapon, which increases the possible maximum penalty. And I think so I was looking at the maximum penalties for all of the crimes that he's accused of, and neither one of them has a maximum penalty of 20-something years. But I think that when you stack all the charges together, the maximum possible penalties, if he was to be convicted of all of them and then sentenced consecutively, he would receive a sentence of 20 or 22 years, whatever it was. That's not going to happen because he basically, it all came from the same set of facts, right? The same acts. And since it all came from the same acts, then all the same set of circumstances, it all happened on the same day. It would be pulling the trigger, even though he did that multiple times. Due to the rule of lenity, his sentence would run concurrently, which is at the same time, just potentially. That goes for any criminal defendant. So you can't run the sentences consecutively, one on top of the other. If it's like, okay, I slapped a person and I'm charged with first-degree assault, second-degree assault, reckless endangerment, all of those sentences would merge together because it all comes from one single act. I hope that makes sense. But because it comes from one single act, all the sentences would run concurrently and not consecutively. So I don't see the possibility for him receiving 20 years in prison. Yeah, so the maximum penalty for assault with a deadly weapon, right? Like a gun or a knife or a semi-automatic weapon, the maximum possible penalty for that is 2, 3, or 4 years in prison. So I think when the media talks about him potentially facing 20 years, what they're talking about is the judge potentially running the sentences consecutively, which I don't think is likely. Now, he can run the gun charge, which is the illegal possession of the firearm, consecutively to the assault charges. Those are two separate set of facts. The possession of the gun in and of itself is a separate crime. But again, it's really unlikely given his criminal history that the judge is going to give him anything near 20 years in prison. And I don't think that that would be appropriate either, just given the facts of the case and his criminal history, which I think is pretty minor. He had the illegal possession of gun and the illegal possession of drugs, and that's why he's prohibited from possessing a firearm. I don't see where he has any criminal history of assaultive behavior. So that is basically the definition of intent, right? For you guys that were asking that question, and for Tory Lanez, and I'm sure that his attorney will at some point explain it to him, but if you are charged with a with an offense, it is not the duty of the complaining witness, which in this case is Megan Thee Stallion, to say, I knew he meant to do it because of blah, blah, blah. It is the duty of the prosecutor to prove that this person acted with a willful intent. And they can prove that by both his words, his alleged words, and the fact that allegedly, he fired the gun more than once. And that applies to anyone. Just take Tory Lanez out of it, but that's the definition of intent. That's what that means, okay? So I hope that that was helpful, guys. I'm done with my skincare for the day. I feel refreshed and great. I'm ready to get going. And I am working on a video about the recent shooting of the black man in Philadelphia. I'm working on a video called The Miseducation of Lil Wayne. I really dive deep in that video. And I'm working on a video about Hunter Biden and the Hunter Biden conspiracy. It's getting really interesting, the different things that I'm learning as I'm looking at those videos. But you guys make sure that you have your post notifications on so that I can make sure that I tell you guys once I upload something. Check the community page. I always have something new there because I like to find out from you what type of videos you want to see and when. I hope you guys have a wonderful Sunday, and I will see you later. Bye.